Topic 1. Coverage. Does the Fair Labor Standards Act apply to my business? The Fair Labor Standards Act applies to most businesses and employees, but not to all. If the law applies to your business or to some of your employees, then you are an employer covered by the FLSA. Your business can be covered by this law in 3 ways. The first and broadest application is called enterprise coverage. You fall under that umbrella if your business takes in at least $500,000 a year in gross sales or total business, and you have at least 2 employees who handle goods that have moved in interstate commerce. As long as you have 2 employees, this second requirement is essentially always met because it includes use of anything that was made out of state. For example, pens, paper, cleaning supplies, phones, computers, or any other equipment. And that does not all have to happen at one establishment. You can have multiple establishments, individual related businesses, or even multiple corporations, and the activities of all of them may be looked at together to determine if coverage applies. For example, meet Sam. She owns and operates 3 locations of a fast food franchise. If these locations perform related activities under common control and with a common business purpose, the Department of Labor would consider all of these locations to be one enterprise and look at all of them as one business to determine if Sam has reached the $500,000 threshold for FLSA coverage. This would be the case even if Sam set up the businesses under separate legal names or even with separate tax ID numbers. Since Sam runs 3 separate locations of the same brand of fast food restaurant, it's one enterprise. In this example, if Sam's 3 locations each gross $200,000 a year, that adds up to $600,000, so she's reached the threshold. Her business and employees are covered. The law applies to every worker at all of Sam's locations, unless an exception specific to certain employees applies. If enterprise coverage applies, everyone who works for your business is subject to the requirements of the FLSA. There are special exclusions that apply to some types of workers, but most employees who work for most covered enterprises have to be paid minimum wage and overtime as the FLSA requires. The second type of coverage is called individual coverage, which applies when some of an employee's job duties involve interstate commerce, meaning business or work that crosses state lines. This can apply even if the employee doesn't work for an employer like Sam that is a covered enterprise. Individual coverage can be based on tasks as simple as making phone calls across state lines, sending emails that go out of state, processing credit card transactions, or traveling to other states for work, covered based on individual coverage, while others are not. Individually covered employees who don't fall under any exception are subject to the law's minimum wage and overtime protections. So even if your business grosses less than $500,000 per year, if you have an employee who, for example, regularly orders products from out of state to be shipped to your office, that employee is individually covered by the FLSA. Anyone who is employed in domestic service, that is, household work in people's homes, is also considered to be doing covered work. This includes maids, nannies, and home care workers. The third type of coverage is called named enterprise coverage. A named enterprise is a business that is covered because it's one of the businesses or occupations the FLSA specifically lists as covered, regardless of its size. These named enterprises are hospitals and other residential care facilities, schools, including preschools, elementary and secondary schools, and colleges and universities, and government agencies. The important part to remember is, if your business is covered or some of your employees do covered work, the FLSA's provisions apply. These include paying workers at least the federal minimum wage, paying workers overtime if they work more than 40 hours in a work week, keeping all payroll records required by the law, and abiding by the law's restrictions on work by children. When employers fail to recognize that their business is covered by the FLSA, it can lead to minimum wage, overtime, record keeping, and or child labor violations. Those violations can result in back wage liability, additional damages due to the employees involved, and even financial penalties to the employer. If you have questions about coverage or other wage and hour topics, please visit our website at dol.gov/WHD or call us at 866-487 9243 for more information.